Good afternoon, everyone. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels. We'll go ahead and get to the JRC here in just a moment, but before we do, as usual, the disclaimers. If you're unfamiliar with the Stop the Shocks campaign or the campaign against the troubled teen industry, all pertinent links are going to be right there in the description box for you. Should you like to do a deep dive on either subject, you're absolutely going to be able to do so. Trigger warning, this channel is marked not for kids for a reason. I do use profanity. And when we talk about places like the Judge Rotenberg Educational Center, you're going to hear vivid descriptions of and catch clips of surveillance footage of people with mental health issues and disabled people being tortured and abused. If you got young children present that are 16 and younger and they watch the channel, parental supervision, very much advised, alright? Alright, now, we are getting back to when the JRC tried to derail the new proposed rule, which has not been finalized yet, back in February, early last year, that I apparently missed. So we're going to go ahead and backtrack a little bit and go over it now. And we're going to get back to where we left off yesterday. And my God, just seeing the logic pour out gives me joy, man. You have no idea. Every time I hear anything logical anymore, it's like a breath of fresh air because it's becoming rarer and rarer every single day. Send help. Send help. Anyways, where we left off, right? Okay. So, if the blanket holding regarding Exemption 5 that plaintiffs urge based on Wiseman is rejected here, plaintiffs alternatively insist that the D.C. Circuit's opinion vacating the final rule voided all decisions concerning the rulemaking. No, JRC, that's not how it works. Let me tell you how it works. If there is an issue, then when you are dealing with banning unsafe medical equipment, if the issue is then fixed, then yes, you can try again. It's called the appeals process. Something you should know about JRC, considering you do it often enough. You see, you don't get to have it where you get to have your appeal, but the FDA doesn't get to have theirs. That's not how it works, Cupcake. I'm sorry. Sorry, School of Karen, Psycho Karen, Sadist Karen. You get where I'm going, right? It's not just some laws for me and not for thee. No. You see, the FDA is able to appeal as well. Which means when the Congress went back and gave them that authority to ban for particular purposes, although I feel like if we just named the actual device in question, we could have bypassed all of that nonsense. But here we are. Now they have the ability to go back and appeal the overturned decision. Just like you do, JRC. You don't get to just say, well, only we can file for appeals. The decision that was in our favor should stand in perpetuity forever. Well, I'm sorry, honey, but this is not the Massachusetts State Court. This is the FDA. Okay? The entitlement. I mean, is it an oligarch that's running the JRC? Is that what's going on? Because then them getting away with literally everything would make a hell of a lot more sense. But anyways, you can't do laws for me but not for thee, JRC. If the issue that caused the original overturn has been corrected, the FDA has the rewrite to do a new proposal. It doesn't matter what you want. That is the law. I don't make the rules. If I did, you would not even still exist. Just putting it out there. But let me continue here. concerning rulemaking ab initio, rendering all decisions the FDA made in its rulemaking process legal nullities. The FDA is allowed to appeal. You don't get to say that, but it's not in our favor, so we say no's. Nobody cares if you say no, JRC. That is not the law. You don't get to make up the rules as you go along. This, in the plaintiff's view, means that an agency cannot invoke Exemption 5 protection of the deliberative process privilege because the privilege is inapplicable to ultra vires decisions, as no decisions existed as a matter of law to pinpoint any agency decision or deliberate process privilege that does not necessarily turn on a reviewing court's critique of the agency action. Rather, as precedent makes clear, this privilege requires that the documents be pre-decisional, meaning that they were generated before the agency's final decision on the matter, and that they are deliberative, capturing those records that were prepared to help the agency formulate its position. They already gave you all the information, JRC. All of their reasoning is right there in the final proposed bill that was supposed to take effect in 2019, but due to COVID did not actually ever get truly enforced, and then was overturned in 2021. Okay? I can't deal with people and their revisionist history, folks. I can't do it. I can't do it. Drives me insane. While the D.C. Circuit concluded that the FDA lacks statutory authority to ban a medical device for a particular use, nothing about that judicial holding undermines the natural conclusion that the final was, in fact, an agency decision, albeit one that turned out to lack statutory authority, or that the agency engaged in a number of other intermediary decisions in the rulemaking process. But essentially, you have them flailing on the floor, pounding their fists like a 2-year-old, screaming, "It's not fair!" Life isn't fair, and this is pretty fair. You get to do your appeal, the FDA gets to do theirs. They're not going to stop just because you say so. Which is a hell of a thing, considering how difficult it has been to get any federal agency to do any digging into these evil bastards. Let me continue. Doubling down on their crusade against the availability of Exemptions 5 protection for attorney-client privilege, in particular to withhold records regarding an agency action that the agency has been found to have taken without statutory authority. Plaintiffs argue that where an agency employee pursues ultra vires activities, he is not acting as a government agent. They gave you all the documentation right there in literally. They name every single source used within the deliberation process of the original final rule within the final ruling documentation. I know. I've read through the whole thing on this channel. What do you mean they're withholding information? What information are they so-called withholding? Well, what do you do behind closed doors and you did this, and this? Yes, it's called politics. You see, we can lobby for the protection of our own just as much as you're allowed to lobby for torturing us. Okay? That is allowed. Not to mention the fact that we are not exactly subtle in the moves that we take against this place. They're all out there in the open. If we're meeting with senators to discuss this horrible place, you're going to find it. Sometimes on the ASAN newsletter, sometimes you'll see it on Autistic Hoya's site, or you'll see it on the web blogs, or you'll catch it in one of my videos. Whatever moves we take, whatever we so-called do behind closed doors, is out there for the world to see. Nobody's withholding shit. I can't deal with these people, folks. I can't. As support for this argument, plaintiffs rely on cases applying the Larson-Dugan exception to Sarbanes immunity, that holding that suits for specific relief against officers of the Sarbanes, allegedly acting beyond statutory authority or unconstitutionally, are not barred by Sarbanes immunity. Plaintiffs reason that, like Larson-Dugan exception, an agency employee is not acting on the behalf of the agency client of the agency attorney when a court has determined that an agency lacked authority to issue a final rule, and thus the attorney-client privilege, which is held by the agent-client, cannot be invoked as a matter of law. By this logic, plaintiffs seek to import the Larson-Dugan exception to Sarbanes immunity, which, if applied, subjects a government employee to injunctive relief, into a totally different context to create an exception to the attorney-client privilege otherwise held by agency when agency employees reach a legally erroneous conclusion. I see. What this means, folks, is the anonymous former students that have come against the JRC, they want names. They don't think that they should be allowed the attorney-client privilege. They don't think that we deserve to remain anonymous for our own safety. You see, they're not just satisfied with torturing us. They want to be able to continue to torture us and hold power over us until the day we die. Obviously. This reasoning is fatally flawed. In the former context, the Sarbanes itself never suffers a loss of immunity because in the circumstances where the Larson-Dugan exception is applied due to employees' ultra-vires conduct, there is no Sarbanes immunity to waive. It never attached in the first place. Thank you. Somebody said it was not me. By contrast, in the latter context, plaintiff's position would result in an agency's loss of attorney-client privilege that otherwise undoubtedly applies when employees consult with agency counsel about actions to take on the behalf of the agency. Anytime a reviewing court subsequently determines the agency employees and agency counsel made an incorrect call. Nothing in the D.C. Circuit's opinion vacating the final rule suggests that the work FDA employees performed in the rulemaking process was done on any basis but on the behalf of the agency. Exactly. Nobody's going rogue here but the JRC. That specific rule promulgated was subsequently found to be beyond the FDA's authority does not make the internal deliberations any less subject to the privileges afforded to the agency because they were doing the decision-making process as the FDA. These are not private individuals. But you're manipulating them. Someone please shoot me. Well, that's about all the stupid I can take today. Not from, obviously, the decision-making folks who saw right through this. Thank you for your logic. It's just even reading some of the JRC's justifications. We're going to go ahead and close out, folks. We don't get very many views on this channel. The few we do get do tend to get removed from time to time, so you know the drill. Please don't forget to hit the like button, hit subscribe, don't forget to hit the comments, and make sure that you are still set up for notifications. We're going to be continuing on with Down the Rabbit Hole and the Snake Oil Salesman series. We really don't want you all to be missing anything. I do appreciate your time, and as always, folks, we here at Spilling Tea absolutely do hope you have a good one. I will see you all next time. Bye-bye, everyone.